Hello and welcome to this Michalsons webinar. We're really excited about today. Today we're doing a session on the priorities of the Information Regulator for 2026. It's an event that we've done around about this time of the year for the last 3 or 4 years. And I'm very pleased to welcome Ms. Mbedzi from the Information Regulator to join us today. She's currently the Acting Senior Manager for Compliance and Monitoring in the POPIA division of the Information Regulator, and she's entrusted with ensuring compliance by public and private bodies with the provisions of POPIA. So Ms. Mbedzi, thank you very much for joining us. I know you're busy. I know the regulator's busy. I know there's lots on the go, so we really do appreciate you joining.
Good morning, John and Karabo. All participants, responsible parties, data subjects, academia, anybody that has joined this session, and essentially all those that are interested in the work of the regulator. It's a privilege and an honor to be with you today. 12 years since the promulgation of POPIA, 10 years since the establishment of the Information Regulator, and can you believe it, 5 years into the enforcement powers of the regulator. And it's a period where we are actively reviewing legislation. But I'm quite honored to be with you today so that we can celebrate some of the progress, pause and reflect, critically assess where we are, and where we must go next, particularly in the year ahead. So I'm very honored to be here. Thank you so much for having me.
Fantastic. Yeah, thanks for joining us. And then we've got Karabo Mokoena, who's one of our Canada attorneys who has got a master's in technology law and an innovation from a university in the Netherlands. So Karabo, very nice to have you with us. And Karabo, you're a panelist, but also the question master today.
Yes, John. Thank you so much for having me and welcome to everyone. And so maybe I can let you know how we prepared for today. You sent many questions, so thank you so much for your questions. We really wanted to be able to answer them all. So what we've done is that in preparation for today, we've looked at your questions and we've tried to incorporate them in how we'll ask our questions. And then also we want to also maybe ensure if you have other questions that you didn't have a chance to submit upon registration, what you can do is you can pop them in the Q&A, and what all attendants can do is maybe upvote the questions that you think, oh yes, this is a good question. I also want to know the answer to this because we do have quite a lot to go through today. So we might not have a chance to go through all your many questions that you've submitted previously and now in the Q&A, but we'll try our very best to do so.
Thanks, Karabo. Yeah, that's great. And yeah, I also want to recognize Ms. Zondi is also here from the regulator. Ms. Zondi is the acting executive for education and communication, and so might possibly help with some of the answers to questions. Very nice to have you with us as well. Great.
Thank you so much, John. And I'm so sorry. I'm trying to fix my camera issue, but when I get it right, everyone will be able to see me. Apologies for that. Thank you for having us.
Yes, perfect. No problem. All right, great. And so the agenda for today is we're going to talk a bit about the regulator's plans. The regulator had a session recently looking at their plans for the next year, and that year runs from the 1st of April to the end of March, which will be 26-27. We'll talk a bit about that. And then we're going to look at a few issues that are priorities for the regulator. We know they are, and we know that you're interested in those. So there are about 5 of those. And we're going to have to touch on them pretty quickly because we only have an hour. So we're going to spend about 5 minutes on about 5 or 6 topics that we think are really important plans going forward. And then we're going to go to your questions. And we plan to spend about 20 minutes answering questions that you've asked in advance, but also we'll look at questions that you've asked during the session in the Q&A box. And then we'll have some closing remarks. And really, that's the agenda for today's session. I'm expecting it to go really quickly. We've only got an hour, and there's a nice crowd here, so I'm expecting a lot of really good questions as well. So thank you very much for joining us. And we always like to get an idea of who's here in the audience before we start these sessions. So I just want to run a couple of polls to get an idea of who's here. So the first poll that I'm going to run is to ask you if you could let us know what your role is. And if it's not there on the list, because we're limited by numbers, you could pop it in the chat just to mention what your role is. Great. So we've got lots of compliance officers. We've got lots of information officers. In-house legal, we've got some directors. Yeah, great. So we've got some project managers, some ops managers. All right, fantastic. I'm gonna be quick with these polls because we've got a few to ask, but yeah, lots of compliance officers, lots of data protection or information officers, which is great. Then the next question we like to ask is, what is the size of your organization? Because it's always interesting to know whether we've got small, medium, large, or enterprise in the webinar. Okay, so small is definitely winning. So that's 1 to 50 employees, but also they're closely followed by more than 1,000. So we have the full spectrum here of small to enterprise. So I guess that makes it quite hard for today's content, but we're talking to everyone here. And then the other thing that's really interesting to know is just to get an idea of the types of organizations that are here. Are you public or a private body? And that also just helps us to tailor the content for the right audience. Okay, so private is winning by a long way. By significantly. So we've got some public bodies here, but mainly it's private bodies. All right, fantastic. Well, thank you very much. That's really interesting to see. All right, so let's talk a bit about the regulator's plans. And the regulator, and this is my summary, but please correct me if I get it wrong. But the regulator issues a strategic 5-year plan, and the current one runs from 2022 to 2020. Sorry about that. There's just a technical problem. But yeah, so the 5-year plan is 2022 to 2027, which makes sense because many of the members, their term comes to an end at the end of this year. So there's a correlation there. And then the regulator, they develop a plan, which is an annual performance plan, which is for each year. And it's not a traditional financial year. It's the public sector financial year. And so the regulator then has these 1-year plans, and there's the 5-year strategic plan, which is really looking at the bigger picture. But Ms. Mbezi, maybe if you could give us a bit more information about how the IR's planning process works.
Yeah, thank you very much. You are absolutely correct. The 5-year strategic plan essentially sets out the long-term vision of the regulator. You're quite correct. We are sort of starting to draw the curtain on the second term. And you're right, the member's term of office is going to be ending in November of this year. And with each term, we sort of put some strategic goals of what we want to achieve. It typically will look at the regulator's strategic objectives, major policy and regulatory priorities, and essentially how we intend to strengthen privacy protection and access to information. So that's what essentially the 5-year strategic plan becomes. But what we then need to do is we now need to sort of break it down and translate those long-term strategies into activities that will become measurable targets for a single financial year. So what we are now going into is the 2026-2027 financial year. And what we have done now is we've developed a plan in accordance or aligned to our 5-year strategic goal. And we sort of break it down to say what targets do we want to set for ourselves in this particular financial year. As you would know, we report directly to the National Assembly, to Parliament. So we would put together that plan, which we already have done. So we do it at the beginning of every year, of every calendar year, so that by the time we get to March, we've finalized it and we go and present it to Parliament. So the one that we've now developed for 2026, 2027 will be considered by Parliament, I think, in the next couple of weeks. And if Parliament approves, that becomes our APP or our annual performance plan. And we sort of now start doing the actual work. And that will then be translated into operations, how we're going to run the office day to day. So that's essentially what our APP and what our 5-year strategic plan is.
Thanks very much. Yeah, and I think the reason why I think people are interested in this process is that it obviously tells people what you plan to do. And so people can then adjust accordingly, or they know what your plans are. And I know many people have been interested in this in the past. And so the current 26-27 plan, or the 26-27 plan, it hasn't been published yet, if I'm correct, but it will be later on in March.
And yes, maybe Ms. Zondi can come in here, but as I indicated, we have finalized it on our end. It will be considered by Parliament, and as soon as Parliament gives us the go-ahead, we will publish it like we do with all our previous plans. So you will be able to find it on our website and our various social media platforms. And you can also reach out to us and we can give you a copy because it will be a public document. So most definitely, as soon as it's presented to Parliament, I don't think we have a date as yet, but it should be, I think, towards the end of March. And as soon as we've done that, we will then publish it.
Fantastic. Okay, great. All right, so maybe let's move on to then a few of the topics that people have shown a big interest in. And I think the first one, which is always, well, almost always the topic people are most interested in, is direct marketing. And the regulator published a guidance note on direct marketing on the 4th of December 2024, which was actually my birthday. So I considered it a present from the regulator for me.
Birthday present.
And I think the other interesting thing here is that the National Consumer Commissioner has recently launched their opt-out registry. I was actually having a look at that, and I registered and had a look at it and to see how it worked. So I think that's another component related to direct marketing. But yeah, does the regulator plan to issue any more guidance, or what are the next steps relating to direct marketing that the regulator plans to take?
Yeah, that's always a topical issue. I mean, you and I sitting here, if we had to ask everyone and run a poll, how many calls have you received in the last 15 minutes since we started? I'm sure everyone has received either a call or an SMS, and that's a very topical issue. What we did in 2024 is we issued a guidance note, and our guidance note really was to affirm the position of the regulator. So we were not introducing anything new. We were affirming the position of the regulator insofar as direct marketing is concerned. And you would remember that the issue has always been that interpretation of electronic communication and whether a telephone call would be included in that definition. And what we did through that guidance note is we affirmed our position because it has always been our position. It's not something that we did an about turn. It's always been our position that telephone calls are included in the definition of electronic communication. So what we did is we issued a guidance note. And now what we expect is that now that we've given clarity, is that responsible parties will comply. What we have done and what we encourage is we see all the communication on various social media platforms, complaints, and we encourage data subjects to reach out to us and to lodge complaints, because what we envisage is that now that we have sort of clarified our position, Obviously, there's going to be a bit of pushback from the industry. So we are ready for that, and we anticipate that that is coming. We also welcome it because I think you and I will both agree that we need a bit of jurisprudence insofar as data protection is concerned in our country. A lot of jurisprudence is coming from the EU, it's coming from Europe. So we do need a bit of jurisprudence. What we anticipate is that we are going to have quite a number, a bit of pushback. And so what we have done is we have taken a few complaints and we are using them as quote unquote test cases. We're going to take them all the way to the enforcement committee, and we want the enforcement committee to confirm the position of the regulator. And if indeed there are any responsible parties that want to challenge that decision or the position of the regulator, we are quite prepared, because this is something that we feel very strongly about, that telephone calls are included in the definition. But I think, and I'm hoping there are a few data subjects on the platform, I think one of the issues that we pick up as a regulator is that as consumers, myself included, we tend to not read our terms and conditions. I mean, how many times have you been buying something and they said, sign here, sign here, sign here? Some of that fine print says, we will share your information with third parties. We will share your information with, our partners and all of that. And all of a sudden, immediately before you leave the store, you've now received 10 phone calls. So what our investigations we're finding with a lot of our investigations is that when complainants come to complain, we then find out that, you actually did consent, or, you are a customer. But that does not mean we will not help you as a regulator. Our mandate, one of our core mandates, is to receive complaints and to deal with them. So we are not going to turn you away. There are a lot of remedies that are available, such as correction of your information or deletion of your information. So you are more than welcome to come to the regulator and we'll assist you. So we are, just to answer your question, we are intensifying the investigations that we're doing, particularly around direct marketing. And we encourage those complaints to come through so that we can deal with them and we can have a precedent on these matters, specifically around the definition of telephone calls and whether it falls within the definition of electronic communication. So that's something that we're looking forward to, and we are intensifying that. We will we sort of put those matters in a special category so that we can deal decisively with those matters. So that is work that, if you look at our APP, we talk about complaints that we'll be handling in the year, and that definitely includes direct marketing complaints.
Great. So sounds like we can expect some enforcement notices related to that, and I agree with you. I think that industry might well take those enforcement notices on review, and we might end up with some litigation relating to that issue. Okay, great. And then Karabo, over to you relating to AI.
Yes, John, thank you. We actually received so many questions regarding the relationship between AI and, personal information and thus POPIA. And, taking into consideration that we should be expecting the South African National AI Policy in a month or so. And, in the policy, it seems that there would be a sector-specific, industry-specific kind of approach to AI regulation in South Africa. And the Information Regulator has been named as, one of those authorities that would be involved, in regulating in that space. And so I think maybe the question here is, what role do you see the Information Regulator playing in regulating AI? And how will POPIA and PAIA, apply in that instance, especially given the fact that it wasn't drafted with AI in mind?
That's correct, but I think even though AI wasn't contemplated when these laws and you're right, both POPIA and PAIA, it wasn't contemplated when these laws were passed and were promulgated. But I tend to think that both pieces of legislation are technology neutral frameworks, which means for me that their principles can still apply to AI systems. Our information technology analysis subdivision has conducted some research on how AI will impact on privacy. It was a pilot study, and I think maybe just to say we are still in the pilot and the research phase of our work looking at AI, but we did do a pilot study to look at the impact specifically of technological advancements on both Poppy and Paya. We will continue to conduct these studies internally so that we understand what our role is. But I'm glad that you mentioned the AI policy, because we as a regulator, we were quite involved in putting that policy together. So some of the provisions that you see is a lot of the regulators' influence. That policy is before Parliament, and like I said, the regulator made significant inputs, particularly around the applications for the conditions for the lawful processing of personal information. We also participate in global working groups and programs where the conversation is about AI and the conversation is about technological advancements. We are, as I indicated in my introduction, that we are working on the reform of both Poppy and Paya to ensure that both legislations respond to AI advancement and technological advancements. Like I said, we're still in the learning phase and the research phase of this. Unfortunately, technology always sort of goes ahead of us, and we tend to have to play catch up. But I think, maybe to answer your question, that I see the information regulator playing some key roles. I think one that stands out for me is interpretive guidance. The regulator will need to issue guidance and codes of conduct explaining how the conditions for the lawful processing of personal information will apply to AI systems. If you think of further processing, lawful processing, purpose limitation, and if you just think about accountability in general around transparency of AI models, I think we have a great role to play in terms of interpretation, oversight as well, automated decision making. Poppy already contains certain provisions around automated decision making, and I think that will be relevant. AI tools are used in credit scoring, for example, insurance, the banking sector, profiling. So I think the oversight role of the regulator will be very important. I do think, like I said, we are still in the research phase, but I think also regarding PAIA, AI may raise new issues around access to information or access to data that is used, as I said, in automated decision making, transparency around algorithms. I think that will be important. So I think, for me, while the legislation predates AI, the principles for me still apply. And I guess the challenge that lies ahead of us as a regulator is how we operationalize that. Then and see how we interpret this, especially in complex AI ecosystems. So I think there's a lot of work ahead of us. There's a lot of research that we still need to do. We'll see what Parliament says about the policy that is before them, and we'll continue to engage with other industry players in this regard.
Oh, thank you.
Great. Yes, I agree. Lots of great points there, and I think we need to do many more sessions to unpack that further.
True.
And just for the attendees, so that's the national AI policy for South Africa that we're talking about. We're expecting it in the next 60 days to be published, and we do plan to do events specifically on that national AI policy when it gets published as well. All right, so the next topic is to talk about POPIA assessments. In last week's stakeholder engagement session, there was quite a lot of mentions around assessments, and I think I was surprised as just how many assessments the regulator has done, and also that you plan to do a number of assessments going forward. And maybe if you can give us some more information about how the assessments work, what are you checking for, what does it result in, and really what are the implications for organizations that are then assessed?
Yeah, when that topic comes up, I become very excited because that's, as you indicated in the introduction, that's where I'm more focused on. I was just looking through the participants, and I recognize some names there, because essentially when people see me, mostly it's usually when something has gone wrong and we're coming in for an assessment. So I'm glad to see a few names there that we've interacted with. If you look at our APP, we didn't include assessments, and that was for a specific reason. As we indicated, the term of office of the members is coming to an end, so we want to finalize a lot of the assessments that are in the pipeline, because if you read POPIA, it says that an assessment is already an enforcement notice. So the members want to finalize a lot of the assessments that we started. You're right. If we look at the stats, we've conducted over 35 assessments since the enforcement powers of the regulator began. So that's as 1st of July 2021. We're not even at the 5-year mark. We're 4 years and some few months. We've conducted well over 35 assessments. So we want to finalize a lot of those in the coming months before the term of office of the members comes to an end. But I think what we look for is essentially compliance with the 8 conditions for the lawful processing of personal information. And the starting point is always Regulation 4, because if you look at Regulation 4, it sort of sets out what an information officer needs to do to be compliant with POPIA. And I was glad in the poll I saw a lot of information officers. If you look at Regulation 4, it says have a compliance framework in place. And the first question that we're going to ask is, where is that compliance framework? And let's have a look at it. And then we start measuring that against the 8 conditions for the lawful processing of personal information. So that's what we essentially do. Obviously, we do look at issues around direct marketing. If you are in that sector, we do look at issues of transborder transfers of information, which is something that the regulator is still working on. We're still working on a guidance note in this year. We started in the previous year, and we're hoping to finalize it yet again before the term of office of the members comes to an end. So we do have a bit of a jam-packed year, as you can hear as I'm going. So assessments is one of those priorities for us that we can't do away with. Luckily, we also have in the provisions of POPIA a provision that allows you as a data subject to come and request for an assessment, or as a responsible party to come and ask for an assessment. So again, what we check for is the same, what you have put in place in terms of POPIA. What was interesting is that earlier this year, when we had the International Data Privacy Day celebrations in Polokwane, we spoke about the fact that a lot of responsible parties in 2021 sort of put documents in place and forgot about them, put them in a cabinet somewhere and forgot about them. And we like to think we've been lenient in the past couple of years because we've been trying to get everybody on board. But I think we're now going to move to a point where we now need to start seeing those frameworks that you've put in place actually being operationalized. We're now going to move to a point of asking you, how are you actually putting it into place? Because what we're seeing is a lot of fancy policies that have been put in place. But when something happens, when there's a complaint or there's a data breach, they tend to not be able to respond to the problem. So we want to move to a point of starting to assess whether the frameworks that we've put in place are actually working, whether they're fit for purpose. So I think gone are the days where we are going to be lenient. Obviously, the legislation in its current form still gives us a bit of hindrance here and there. The executive for POPIA likes to say that POPIA is a very friendly piece of legislation. And just to answer your question of what do we do, once we come in and we do an assessment, we issue you with a report, which in terms of Section 91.3 says it's already an enforcement notice. But that enforcement notice contains recommendations, and it gives you some time frame to comply with those recommendations. And it's only in instances where you don't comply or where you don't respond do we then move to the issue of an infringement notice. If I had to give an example, if you would remember, around 2022, 2023, we finalized the DISCAM assessment. That DISCAM was given sets of recommendations and they complied. And that sort of becomes the end of the story. Hence, we say it's quite friendly. But in instances, and if we take, for example, the Department of Justice matter, which we're still in court about, is that they failed to reply within the time frame, they failed to implement within the time frame. And then POPIA says then we then move to the issue of infringement notices. So as it's currently worded in POPIA, we're still quite friendly. We are working on legislative reform around that. We want to see ourselves with a bit more teeth, not just bark. But we're still in a phase where the current legislation still allows you some time to fix what we pick up and put in place some of the recommendations that we do make. So that's a very big aspect of what we're doing. Assessments is a very big chunk of what we do in compliance. Yeah.
Sorry, John, you're on
John,
mute.
you're muted. Sorry.
Sorry. A question we get from many people is that the self-assessments that are in the regulator's portal are very good, and people are concerned, I guess, that if they complete those assessments, and particularly if they're honest, and so they end up with a score of, well, we 12 out of 20. Is the regulator going to look at those results and hold it against the person who did the self-assessment?
Absolutely not. I think firstly, we need to give props to our CIO, the Chief Information Officer. He's been doing a lot of work on our portal and trying to bring in different tools to assist our responsible parties and our data subjects. I think there's a disclaimer on that self-assessment that says we don't get the answers on our end. So I don't get to see that you've scored 12 out of 100. So we don't use it against you. As the name indicates, it's a self-assessment tool. It's just sort of to give you guidance as to where are you in your compliance journey? Where do you still need to improve? So we will not use that against you. We will not use it to come and assess you or come and investigate you. That is not how assessments work. That is not how investigations work. So that is just a tool that we're trying, and this is just us trying to respond to some of the questions that we get from members of the public and specifically responsible parties in terms of how can we as a regulator assist on the compliance journey. So that's just one of the mechanisms that we are looking at. We, like I said, our CIO is really, really great, and him and his team are spending a lot of time looking at what other jurisdictions are doing, looking at what other regulators even in the country are doing around trying to bridge the gap between the regulator and a responsible party, because part of our mandate also, it's not just about wielding the stick, it's also about guidance. It's part of our mandate. So we are trying to see how do we sort of bridge that gap and bring everybody on board on this journey, because it really has been a journey. Like I said, we are now almost 5 years into the enforcement powers. It really has been a journey for the regulator, and we want to bring people along. So I think that's a very good tool that we've established, and we're looking at other tools that we can bring on board. But no, everyone can calm down. We don't use that against you.
Okay, perfect. Thanks for that. And then just to pick up on the fines. So the fines that have been issued, some have been paid, some have been taken on review and are going through a judicial process, and then some just haven't been paid. And what is the regulator doing in that regard to recover those fines?
Yeah, that's an interesting part of our work. As I said, we're on a journey and we get to discover new things. So 2 cases have come up. If you remember, in early 2024, we issued our very first fine in relation to direct marketing. It was against a company called FT Rams Consulting. And again, like I said, we went through the process and we issued an enforcement notice. They didn't comply with all the recommendations. And the law says then we then can issue an infringement notice. So there was a fine that was issued, if I'm correct, it's 200,000 Rand that we issued against them, and they were given a certain period within which to pay that fine. They failed to pay that fine. And in terms of Section 109, it says we can then take our infringement notice, lodge it with a competent court, and have that infringement notice essentially made an order of court, so that we can then try and recover those monies in a civil manner. So that's what we are doing currently with FT Rams. Another one was Bloberg Local Municipality. That was as a result of a complaint that came. It went through the entire process, went to an investigation. The enforcement committee issued an enforcement notice Likewise, they also did not comply with the recommendations. In actual fact, they didn't respond at all. And we then issued an infringement notice, which also was not paid. So we are taking that process of Section 109 to go and file our infringement notice with a competent court. So that's something to look out for in this coming year in terms of it will also be new to the courts as well. So we'll see how that plays out. But we do have remedies. So I think the message here is do not ignore the regulator. Like I said, POPIA is quite a friendly piece of legislation. So if we give you recommendations to all our IOs on the platform, all our compliance officers, please don't ignore the regulator. This is a case in point. The consequences of ignoring the regulator or of not implementing the recommendation. There are remedies available in POPIA for the regulator, Section 109, and we've now started to use those avenues. So this is something to look out for, and we'll see how the courts deal with this.
Fantastic. Thanks very much, Jan. Talking about courts, I think another key issue that comes up is what is personal information? And this issue, many people ask us, because if it is personal information, then POPIA applies. If it's not, POPIA doesn't apply. So it's an absolutely critical issue, and in many other jurisdictions as well. And the litigation that's been ongoing between the Department of Basic Education and the regulator is really, for me, the key issue there is about what is personal information. And I believe that the regulator is actually in court today on this issue.
Yeah. So that's also one that has kept us quite busy over the years. You're quite correct. The leave to appeal the ruling of the Pretoria High Court that came out, I think it was around the 9th of December, if I'm correct. That matter is currently in court as we sit here. So that is something that we feel very strongly about. But I think as we indicated in various platforms and in a number of our media statements, is that we encourage this because we need the jurisprudence. We need the precedent to be set. We respect the South African courts, and we respect the judgment that has come out from the Pretoria High Court. But as we had indicated, we don't agree, and that's why we're currently in court to seek leave to appeal their ruling so that we can get access to the Supreme Court of Appeal. And you're very right. This is going to be very critical in terms of how do we define personal information, how do we look at things like identity numbers and account numbers. So the High Court made certain pronouncements that we don't necessarily agree with, and that's why we are pursuing this avenue. I think the chairperson has been on record to say this is a matter that we feel very strongly about. But I think what is encouraging for us is that South African courts are now starting to grapple with the issues around POPIA. Like you said, they're starting to grapple with questions of what constitutes personal information. There's a lot of temptation to sort of prioritize certain things as what people tend to call sensitive personal information. POPIA doesn't have sensitive personal information, it has special personal information. And there are different thresholds for compliance with different types of information. So this is going to be really an interesting one that we are interested in, one we're quite excited about, regardless of what the outcome is, because it does strengthen the jurisprudence, but it also gives clarity to the regulator as we proceed. Is there then, from whatever is going to come from the courts, is there a need to maybe have a guidance note following what the courts will decide? Is there a need to clarify certain things? If you look at POPIA, it's been written and certain things have not been defined. I think an example is personal information impact assessment. It hasn't been defined, but it's required. So we need, as a regulator, to give that guidance. But we quite appreciate when these matters end up before court, just as with what we discussed earlier on direct marketing. It gives us something to hold on to. It provides a lot of guidance on our end. So we are looking forward to that. So that matter is currently on as we speak, and hopefully, obviously, from a regulator point of view, we are hoping that we will be granted leave to appeal, so that this matter can go to the Supreme Court of Appeal, and it will be very interesting to hear what they have to say. Will they affirm what the High Court has said? Will they have a different interpretation? And for us, that can only enhance our work. So yeah, that's something we're looking forward to.
Right, so that's good. So we're going to go to questions soon, but I just have two more questions for you. You mentioned the personal information impact assessment, and I know that you mentioned last week, or the regulator mentioned, that you plan to develop a guidance note on PIIAs, and I was wondering if there's any more information you could give us around that guidance note.
Yeah, so we it's part of the plans that we have in the upcoming year, and maybe just to give a bit of context as to why we decided to do this. Like we said, we've done quite a number of assessments in the past. If you look at POPIA, it says you must conduct a personal information impact assessment, but it doesn't tell you the how, it doesn't tell you the when, it doesn't even tell you the why. So we felt that that is very important to clarify. And I think from our perspective, and there's been a lot of questions from various responsible parties that we've engaged in to say, why does the regulator not develop a template? I think for the regulator, it's not so much a template, because all of our processing activities differ. So for us, it's not so much as a template, but it's more of a guidance to give the when, the why, and the how. So that's something that we are looking at. We are looking to develop the first draft in the first quarter. And as I said, before the term of members ends, to have it approved, and hopefully before the end of the financial year. So anywhere between January to March 30, 2027, to have it published. So essentially, that's the work that we're going to do. But it was informed by the fact that there have been many varying interpretations of it. The GDPR does give some good insights into it. But obviously, as a regulator in its own right, we don't want to copy and paste everything that is coming from other jurisdictions, but they do give a very good yardstick of what we should be doing and where we should be going. So obviously, we're going to look at what sister organizations in other jurisdictions are doing around this work, and so that we can give a bit more guidance, so that there is uniformity, again, not in the template, but uniformity on what it is, because we still get questions, you would be surprised, of what is it. So our guidance note is going to focus on that, to say, what is it, when should it be done, by who should do it, by when, under what circumstances. We're going to look at a few examples. Again, it won't be a one size fits all, or it's not a one size fits all. So we found that it's very important for us to clarify, but also to give direction on what do we as a regulator expect from that, so that we are all on the same page. So that's work that we will be undertaking as of the 1st of April.
Okay, fantastic. Great, that's very interesting. So I think let's go to some questions. Karabo, which questions do you think we should answer? I know it's difficult, there are quite a few.
Yeah, so we have so many questions in the Q&A box. So please go to the Q&A box and upvote the questions that maybe you want some answers to. But I mean, maybe we can start with the burning questions that were submitted when people were registering. And the first one will be, should all data breaches be reported to the regulator, or only high-risk ones? And is POPIA being amended to clarify this?
That's a very good question. I think we receive that question at least once a day. Currently, yes. The answer is yes. All data breaches must be reported, including those that we call human error, slip of the finger. Currently, those are all reported to the regulator, and each and every single one of them will be assessed by the regulator in terms of our risk matrix. But you are quite correct. If you look at other jurisdictions, they have sort of come up with mechanisms to say these are the types of breaches that must be reported. That is research that we are currently working on. Those are policy decisions that we as a regulator need to take, and that is front and center. I think it's on the table of members as one of the things to consider, to say, should we have some sort of threshold? Should we maybe even develop a system that will be able to categorize them and advise responsible parties that this is the one that is reportable? So those are some of the things that we are looking at. We're very much aware of this topic. This is definitely something that we're looking at. But just to give a short answer, yes, all data breaches at the current moment must be reported. And please don't underreport. We will find out about it. So please, every data breach at this point must be reported, including the slip of a finger.
Oh, well, yes. So you heard it here, folks. You have to report every single one. Don't make the mistake. I'm going to go to the Q&A box. We have one with 5 upvotes. We'll just take one of those. And I think it's topical. Leslie's asking, so there are public platforms which still include open access to personal information, especially related to property owners. And then she asked, when will this be addressed or enforced by the IR, by the Information Regulator?
Yes, thank you. And I see Ms. Zondi is trying to answer some questions on the chat.
Yeah.
So any questions that we'll miss, at least Ms. Zondi is here to assist us. That's actually something that comes through complaints. And the reality is, as a regulator, we won't be able to know about everything. So we really, really do implore on our data subjects to let us know about any potential breaches of POPIA. We will thoroughly investigate these matters. We do have a good working relationship with the CIPC. For example, if you look at our portal, how it has been designed, there's an interface with the CIPC. So we please we encourage people to come up and report these platforms, these organizations. We do receive quite a lot of complaints around property, around estate agents, and processing of personal information in that sector. So that's a bit of work that is being done around the sector. As we had indicated, there's some colleagues on the platform will know we had stakeholder engagement around gated access, which obviously does touch on property and gated communities. So we do that. We have a relationship with CSOS, so we do handle a lot of those complaints, but particularly around channels and platforms and organizations, that have that kind of processing. Please do let us know. Please do lodge your complaints so that we can look at them and we can assist you with that. We won't be able to know everything, so we do rely on you to inform us about those kinds of issues.
Yes, I will say I think the information regulator is so open to stakeholder engagements, and so I also agree with you for any data subjects to really approach you if there is anything that they say, hey, listen, maybe have a look at this. So maybe we can go on to the next question. From our burning questions, we have the question: what industry or sector is the information regulator going to focus on in 2026, and including any implications of the coffee bill?
That's a very interesting one. People want me to reveal my plans for this year. I'm not going to tell you who I'm targeting. But look, what we've done in this new financial year is we are also going to be doing what is known as monitoring. If you look at section 40, it says we have the mandate to monitor. And it then says and also to enforce. So what we've done, we did a bit of a pilot in the last quarter, in quarter 3, and currently in quarter 4, where we are monitoring compliance. So we are looking at your compliance journey. Where are you? Have you put things in place? And we're doing this before anything goes wrong, before we have to do a formal assessment or a formal investigation that will attract enforcement notices and fines. We've sent out a few of this, and I saw a very interesting post on LinkedIn where somebody said this is not a drill. And when we did our presentation, we sort of screen grabbed that because it was very true. It is not a drill. This is something that we are doing. And the reality is, if you look at the number of our registered responsible parties, I think the number is at 144,000 out of almost 3 million registered entities with the CIPC. And here we're just talking private entities. So you can see that the number is very small. So when we do this monitoring, we're trying to encourage that compliance, and we're trying to bring everybody on board. So what we do in our monitoring is we sample. Obviously, again, we won't be able to reach everybody, but please do not think we will not reach you. We will reach you eventually. It might not be in this quarter, but it may be in the next quarter. We sample and we sort of try and balance between the private and the public, because really there's been a question specifically in Parliament about, are we going to get to a point where we're going to name and shame those responsible parties that are not complying? Because Parliament is saying we need to get to a point where everybody is on board. We need to get to a point where everybody complies with POPIA, because the complaints are a lot. If you look at the numbers that we projected last week, the numbers are astronomical. The number of data breaches are astronomical. So we need to bring everybody on board. So we'll be doing monitoring. I'm not going to tell you the sector. Private and public bodies is what we're going to be looking at. But also in terms of our assessments, we're trying to cover everyone. There are industries that we have not even gone to yet, that are flying under the radar. Please do not think we don't know about you. We do know about you. Like I said, we have a good relationship with the CIPC. So yes, there are no holy cows. We will reach you eventually. Again, it might not be today, but definitely tomorrow or in the near future. We will get to you. And again, the process will be exactly the same. If it's an assessment, the process that we just spoke about with John, about enforcement notice, infringement notice. With monitoring, it's a bit more friendly fire. We come in and we look and we give you recommendations as to what you have not put in place or what you still need to address. And, again, if you address it 100%. If not, then that gives us a reason to say, do we want to come in and do a formal assessment? Do we want to come in and do a formal investigation? So please, again, when you see our monitoring letters, do not ignore us, please.
Yeah. Oh, okay. So we're going to answer a question from the chat. It has 8 upvotes, so we'll have a look at that. It says, what is the best POPIA compliance framework the regulator has seen? Was it one document? Was it a set of documents? Is there a template? Is there a guide available? Like, what are people supposed to do there?
Oof, this word of template. There will never be a template, because industries are not the same. Processing activities are not the same, and the legal basis for why you process. The banking sector processes in accordance with specific legislation, so does the insurance sector. Direct marketing is a whole nother ball game. FMCG, it will never be the same. In terms of, and again, we are very shy from prescribing, because again, we are not the same. If you look at section 19 that requires you to adopt best practice, we're not going to say ISO is the best or NIST is the best. We are going to say to you, look at your particular industry. What have you as an organization adopted? And we will then hold you against what you have adopted. So I'm not going to say any particular framework has been the best. You need to look at your specific investigation, because again, if you look at compliance best practice, is a compliance framework one document? That will be one lengthy document. You can have a subset of documents, because again, in almost each and every condition of the lawful processing, there's something that is required from a governance and compliance perspective. So I'm not saying go have 100 separate documents and hopefully think the regulator will not go through all of them. We will, but I'm also not saying have one particular document. I'm saying look at your industry, look at what best works for your particular organization. Some organizations are quite small where they can have one document, but you have big multinationals, you have big corporates, the banking sector, the insurance sector, they're quite big. It might not be practical to have one document. It might need to have various documents. So look at your particular organization, look at your particular industry, and look at what best practice is. And when we come in, we hold you to that.
Yeah. Well, thank you so much. I think that's all the time we have for questions. And I think most of the questions that you did submit earlier were answered during the webinar. So thank you so much, Ms. Mbetsi. John, any closing points and take-home points?
Yes, thanks very much. Yeah, there are always lots of questions, and I see that there are many still there. You can find answers on the Michalsons website, but also through the regulator and on their website. There are answers to many of those questions. Yeah, so I think it's been a really fascinating discussion, and for us as Michalsons, we believe that the role of the information officer is a really important role in society. We're passionate about access to information and about data protection. And so we've developed a program called the Information Officers Program that helps information officers to fulfill their responsibilities as an information officer. We've made a list of 21 responsibilities that we think are required, that come from the regulations and from the law and from business requirements. And we help information officers to fulfill those requirements. So if you want to find out more about that, you can email me at john@michalsons.com. But I think, so my closing point really is information officers are important. These laws are important, and we need to comply with them. And I really would urge you to work hard at it, and to take cognizance of what the regulator says, and really work towards compliance, not necessarily because you're scared of the regulator, but because it's an important thing for your organization and for society to get right. So, Ms. Mbedzi, is there any closing remarks you'd like to make, or final thoughts?
Yeah, I think, again, thank you very much for having us. We really do appreciate the opportunity to be able to engage with responsible parties, with data subjects, academia, and everybody present. Thank you so much for the questions. I encourage you, please do interact with us. I'll give Ms. Zondi an opportunity to just give us some tidbits on where you can access us, but please, we do encourage you to please engage with us. We have an iSupport function where you can send through various queries, and we'll be able to provide guidance where we can. Please, again, to all our data subjects, please, when you engage with responsible parties, think and remember all your rights, and please do engage with us if you feel that any of your privacy rights or access rights have been infringed, because we do have a dual mandate. Please feel free to reach us and speak to us. Call us. We are available. Ms. Zondi, if you could maybe give us where we can reach the regulator and the staff of the regulator. But John and Karabo, thank you very much for having me. We look forward to more of these sessions, and yeah, let us continue the conversation on various of our social media platforms. Thank you so much.
Yeah, thank you very much. Ms. Zondi, would you like to mention anything in closing?
Yeah, maybe just in half a second. I think yourself, John, Garabo, and Hangi, you've actually covered where we can be accessed, such as our website and our iSupport services. I tried to keep up with the questions on the chat, but it's a lot. However, we do really invite you to use our iSupport services. Currently, our lines are down because of migration issues, but we do really respond to our iSupport services. But I'd like to just encourage everyone to please follow our social media platforms. We try to keep you updated and informed, and even educate through our social media platforms. And I did see some recommendations for learning materials and awareness materials. We welcome those as well, because we want to assist you to understand these legislation and also comply with it. So we welcome those as well. So please do interact with us on our digital platforms that are made available. Thank you.
Great. And Karabo, any closing thoughts?
Oh, yes, this was really great. And like John said, I think compliance here is really not just for ticking a box, but it's actually really good for you and your organization. You know, processing personal information lawfully actually really also protects you and allows you to conduct your data-driven transformations in your business like responsibly and actually get the best out of it. Yeah, so guys, let's comply. Yeah.
Great. And then very lastly, we always like to get feedback on our events. So if we could just run a quick poll to see, get some feedback from you on if you enjoyed today's session. If you do have any feedback, you're also welcome to email me if you want a different format, or if you think we didn't answer enough questions, you're welcome to message me. We believe feedback's the food of champions. And while you answering that, which is great, it's very positive feedback. I really just want to again thank the regulator. I really do appreciate your time in participating in these events. And as Karabo mentioned, I think is that the regulator really is very transparent and very engaging, which is fantastic and really nice to see. So thank you very much. I really do appreciate it. All right, thanks for the feedback. And yeah, I think time is up, so we're going to have to leave it there.
Yep.
But thank you very much for attending. To all of you who attended, I really appreciate it, and thank you for your engagement and questions. And yeah, we hope to engage with you again soon.